Did they give us the fatality grade? Why does this thing echo? Okay. All right. Yes. Hey. Okay. When I address you, I had thought you would. Please, you can step down and go back. Thank you very much. I'm sorry. So call up the matter for. Who is the claimant? Whose witness are we going to take? You're the claimant. Yes. Yes. Is he? How this is echoing again. Why is it? So
What is the witness? I know. Have you communicated with her?
Okay, she's here. Okay.
By who?
Very well.
So the business of court today is for commencement of trial.
Court business. Will you please court, my lord?
Yes.
Olale Koindo, my lord, I appear for the claimants. Raymond Ezebo appears with me.
Yes. Yes.
But we are ready to proceed with trial as scheduled this afternoon.
Very well.
Court.
I'm going to swear your witness. It's going to be sworn. Before she gives evidence. What's her name?
Ifeoma Francis Ezekaka.
Ifeoma
Franca, sorry, apologies. madam.
Frances.
She
Hello,
said
Frances. No, it's Frances actually. Frances.
okay. Frances.
Yes, ma'am.
Are you a Christian, Muslim, or are you a pagan?
I'm a Christian, my lord.
Okay. Would you rather swear on the Holy Bible,
or would you like to affirm?
I would like to swear on the Holy Bible.
Good. And you don't have anyone close to you there?
I do. I do. Got my Bible.
Very well. Then you say after us. I. Your name.
Ifeoma Frances Ezekaka.
Okay. I do solemnly swear.
Do solemnly swear
That the evidence I shall give in this case.
that the evidence I shall give in this case
Before this
court
shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So help me God.
So help me God.
Okay. CW1 sworn on the Holy Bible.
Yes. Witness, please tell the court your name, your address, and what you do for a living.
Okay. My name is Ifoma Frances Ezekaka. I currently live at number 27 Sutherland Road, Wolverhampton, United Kingdom. I'm a pharmacist.
Mama, please, can you take it slowly? My lord is actually writing. Please take it gently.
Oh,
So
okay,
accommodate
Yes.
the court.
All right. I'll start
I
again.
got as far as 27
Sutherland Road,
Sutherland. Okay.
Wolverhampton, United Kingdom.
So, United Kingdom. Yes.
And I'm a pharmacist.
I am a pharmacist. Very well.
Mama, do you recall making statements, two statements in respect of this matter? One is dated 22nd June 2021. The second is dated 6th February 2023. You recall making
Yes, I do.
Yes. 2nd of June 2021. I take it you said 22nd of June.
very well. The first one's 22nd June 2021. And the second one, my lord, 6th February 2023.
Yes. You've seen this. This one is 6th February 2020. The second is 6th February.
February, very well, 2023.
Is it, do you have it? Defense? Yes, I don't think the court has been served either.
My lord,
Because the last process here was served on the 25th of October 2022.
oh, my lord, so the defendant filed their statement of defense, in response to which we filed a reply. The said second statement on note was filed together with the third reply, and it was put together. I'm sure it was served, and I'm sure a copy will be in the court file. I actually have it with me, my lord. It's annexed to the reply. If you look closely, you will see. Can I have it? My lord, I apologize, my lord. I'm aware that counsel spoke to my colleague to say that the process he has as a reply is not clear. And I'm saying that the statement on oath is annexed to the said reply. If he has it, he just show me. I'll point it out to you. Can you just show me the said reply?
My lord, I have copies of the originating processes served on my client. And my complaint earlier was that that process, some pages are not clear, meaning they are not eligible.
No, this is
requested for another photocopy that will be eligible.
they brought
I'm
it this
not
morning.
aware of any reply or any statement attached thereto. It was filed on 6th of February, but I don't have a copy of it. Yes, 2023. I can avail counsel on the other side, my whole file, so you can peruse and see.
Well, I've just been served this. I've just received it.
As a copy.
That is the reply to the statement of defense, where her second statement on oath is attached.
As a copy.
I just got it now, and the court doesn't like this.
Pardon me.
When did you really file it?
My lord, it was filed on 10th
10th February.
As a copy. 10th February. Yes.
There is 16th. Okay.
My lord, in any case, my lord, I would have expected that counsel would inform the court. They actually have a motion for extension of time. It was out of being interested in speedy expedition and speedy hearing of the case that we had proceeded to file the reply while they have not even moved their motion for extension of time. My lord. This motion for extension of time, which has not been. But in any case, we don't want to stall to wait for them to file, so we went ahead to file the reply to the statement of defense.
My lord,
Okay.
this matter came up
Yes,
last.
because your statement of defense comes first in time before this reply.
Yeah. My lord, this matter came up last on 25th of October, and we were represented in court by one B. Adejari on that day, and he made me understand that that application for extension of time has been moved, except if there is something to the contrary. That application, my lord, is dated the same 20. I think the court even stood down from what he told me to take that application for extension of time on the 25th of October.
Okay. You are represented by who?
Kanyip, Adetola K, Adeyemi, and B. Adejari. And Adebite Oluwatife Adejari.
But there was no application or granting of any motion.
I'm so sorry.
It was on the 29th day of March that you, my lord, Mr. Okechukwu, applied for, you moved the motion dated 21st of February 2022, filed on the same day that the relevant rules. Application was granted without any objection.
So that's not application. Because we filed for the first time on 24th of October.
Okay, it must have been granted. And the matter was adjourned to the 10th day of May 2022 for hearing of the matter virtually.
My lord, that would be an application of the claimant, my lord. That is not our application, my lord.
Then I don't think you've made any application.
I apologize. I apologize.
You've not.
May I humbly seek the leave of the court to move our application? It's a motion.
At this stage,
my lord, I pray for the indulgence of the court.
To move application for regularization. The application has not been, have you served it?
Yes, my lord, I confirm service, and we have actually not, we are not opposing. We have actually filed our reply.
I must be.
So you abridge your application. You abridge your application since it's not opposing.
As the company is, my lord. And I will seek leave of the court to move in terms of our application dated 25th of October 2022, and pray that this honorable court grant all prayers as contained on the face of the application, sir. I'm most grateful, sir.
I've recorded you saying you're not objecting, like you said.
Pardon me,
You're
madam.
not objecting.
Very well, madam.
So the application of counsel is hereby granted without any objection, and the court orders are spread on the motion paper.
As a corporate.
Yes. So of the extension of time. Yes.
May we apply to proceed to continue with the hearing of the case?
Yes. Nothing stops us from continuing. Is there anything that stops us from continuing? Counsel. Having taken your motion, nothing stops us from continuing from where we stopped.
As the court pleases, sir.
Continue. Francis, are you there?
Yes, madam.
Yes, my lord. Yes, my lord.
Okay.
I'm
Very
here.
well.
My humble application then would also be, having filed the reply before the due time, I apply that same be deemed as properly filed and served.
Yes. That come again.
Having filed the said reply
Yes.
before the time that is due for it, I pray that said reply be deemed as properly filed and served. I'm very grateful, my lord. Yes. Madam Ifoma, what do you intend to do with the two statements that you made before this court?
I wish to adopt them as my evidence in these proceedings.
Yes. We have also relied on documents in your said statement, and you have front-loaded them before the court. I'll read them out as presented in your list of documents. Number one, you relied on a letter of employment. Number two, you relied on an email dated 9th June 2016. Number three, you relied on an email dated 15th June 2016. Number four, you relied on email trail from 27 July 2016 to 4th August 2016. Number five, you relied on an email of 25th October 2016. Number six, you relied on an email trail of 4th November 2016. Number seven, you relied on an email trail from 18 January 2017 to 10th February 2017. Number eight, you relied on an email dated 14th February 2018. Number nine, you relied on claimant's solicitor's letter dated 19th March 2018. Number 10, you relied on a fee note dated 26th January 2021. Do you confirm this?
Yes, I do.
Allowed to seek to tender the said documents and evidence.
Okay.
In addition to this, we have the statement of compliance with the Evidence Act. Also seeks to forward it to the court.
Certificate, no. Non-statement. Certificate of compliance.
Very
It says
apologies, my lord.
Okay.
I'm very grateful, my lord. Certificate of compliance.
Maybe there's the words in there. It's working now. It's working.
Okay. That's it. So, okay. The 10 documents listed by the claimant on the 31st day of March 2021, titled Claimant's List of Documents to be Relied Upon at Trial, are hereby admitted in evidence serially to and marked exhibits C1 to C10 respectively. Also, a certificate of compliance with the provisions of Section 84 of the Evidence Act 2011 is equally admitted in evidence and marked exhibit C11. Okay.
Madam Ifoma,
Yes, okay.
what is the prayer to the court?
Okay, so I pray the court to grant all my reliefs in my statements of fact. Did you hear me? Did you hear me?
Yes, we heard you clearly.
Okay, thank you, my lord.
Yes.
But that will be all for examination in chief. I'm very grateful, madam.
Cross-examination. Yes. Remember that you are limited to number of minutes. Okay.
Madam Ifeoma, I have very few questions,
Okay, thank you.
and I appreciate if you can cooperate with me so we can move very fast.
All right, no problem.
In your statement on hold,
Hmm.
dated sorry, where's the last one? The one of 2021. I'm so sorry. Okay. You repeatedly stated that you were advised to resign. Am I correct?
Yes, yes, it was.
You agree with me that was an advice and not a compulsion or a compelling statement. Is that true?
Well, in that case, it was more than an advice because the company had even gone ahead to circulate the communication to all the staff saying I had resigned, even before I had. So at that point, it was no longer an advice. It was practically compulsory because it had been communicated that I had left the company even before I saw the said email or responded to it.
Can I go on, my lord?
Just 1 minute.
Where's the last page of this document?
Yes.
You stated that you were given a document titled Provisional Letter of Employment.
Yes, please. I was.
Was that the only document that governed your relationship with the defendant?
Yes, that was the letter I signed. And I also have the copy. Okay.
So my question is, in the course of your employment from 2014 to when you resigned in 2016, was that the only document that governed your relationship with the defendant?
Yes, that was to my knowledge.
Yes.
Are you aware that the company has a different document that governs other provisions of the employment, which is not in that letter that you stated, such as maternity leave, such as normal leave, such as work disciplinary measures? Are you aware?
I am not aware.
Such as what? Maternity leave.
Disciplinary measures.
Okay. And your answer is that you're not aware?
No, no, my lord, I'm not aware.
Yes.
Grateful. In that letter, that's provisional employment letter. How do you know the number of days that you ought to have applied for maternity leave? Was it contained in that letter?
Okay, so it was not stated in the letter, and as such, the industry standard was what would apply. Okay, because the things that were stated in the letter were things that were exceptional. Okay, there was no conditions that stated that there was any deviation from the industry standard for maternity leave.
What do you now regard as the industry standard? Where is it contained?
Yes.
Okay, so the industry standard is, just give me one moment.
I hope nobody is there to assist you.
No, I'm just referring to the documents on my other PC. Can you see that? It's my PC. And if you like, I can do a sweep of the room. This is my office space. I would do a sweep of my room. It's my office space. The door is securely locked. And I've got nothing but my work equipment here, okay? So just give me one moment, my lord.
Okay.
Okay.
Right, so whilst I'm just trying to see if I can get a reference, but without even referring to any document, okay? The industry standard as I know it is 3 months maternity leave in the private sector, okay? And seeing as this was not the first company where I had worked, where I had to take maternity leave, okay? Prior to coming to the company, I had worked in another company. I'd had 2 children there, and I'd had cause to take maternity leave, okay? And also, I made an application which was granted by the company. At no time was there any denial of my request. In fact, it was accepted and I proceeded on maternity leave. So it was 3 months. That was the acceptable industry standard. Okay.
So
Does that answer your question?
I have, yes, of course.
My lord.
That everything you just told the court now is not contained in any document before this court. Will you agree with me? The industry standard you stated now is not contained in any document before this court.
Well, this is the first time. Yes, because this is the first time it's coming up. I did, yes, I did send the statement of fact and it wasn't queried. Yes, it wasn't queried. So, yeah.
So that, yes.
Informer.
Yes, my lord.
Francis, yes.
Yes, my lord.
Remember, I'm not a machine yet. So
Oh,
when you read out the answers, you try to let me write what you're saying.
I'm so sorry, my lord. I forgot that you're writing. Okay, so in response to the last question he asked about what I just said being contained in any documents before the court, I said it's not contained in any document because this is the first time this question has been raised. I had stated that in my statement of facts that the industry standard was what I had applied, and no question was raised in the by the defendant, of which I would have had cause to refer to the necessary documents if that had been asked. Yes, I can hear you loud and clear.
My question is direct.
And I've answered.
The question is, that industry standard you just stated is not contained in any document. It's a yes or no answer.
My lord, the witness has answered the question. She just further explained. I think she has answered. I said it's not contained.
My answer is it has not, but that's she went on to say that it's just because this is the first time it's coming out, but it's not contained in any.
As a couple, sir.
Yes.
Can I go on?
Yes, sir.
In the course of your employment, are you with me?
Yes, I am.
Okay. You will recall that you issued at least about 4 queries bordering on negligence of duty, poor performance, and so on. And you have failed to avail this court the fact and details of these queries. You will agree with me that you have concealed facts before this court, yes or no?
I have not considered any facts. I have not considered any facts.
But you were issued queries.
I did in my response states clearly. Yes, I did accept that those queries were issued, and I further explained the circumstances surrounding the query. And if you would also recall, I had been in this company for a year before these queries came. So I did explain clearly in my response the circumstances leading to that query, to those queries. Yeah.
Yes.
To that extent, you didn't maintain a clean record of performance with the defendant. You agree with me?
I disagree totally with you. I disagree totally with you. And I would also like to draw your attention to the fact that the case in hand is about the non-payment of my salaries, my out salaries that were paid. I have never, I haven't it's not about whether the company decided to ask me to leave. I left
Madam,
and I
if you
was paid.
just answer
That's what
direct,
I have answered you. I answered you first before I
I
answered
put
you.
down
just
her
save time because there are other counsels in court.
Yeah, I have answered you.
He said she disagrees with you that she did not maintain. I put down what she writes. I put down what the answer of your questions.
As a corporate, as a
It's
corporate,
on record.
you claimed that you made several demands for payment of salary. Is that true?
Yes, I did, as can be seen in my evidence.
Okay.
My evidences.
What do you have to show this court that you made such demand and it was not paid?
There's a list of emails which has been entered in evidence. And on those emails, I had made series of requests for my salaries, outstanding salaries to be paid over a period of several years. The last communication being on the 19th
The answer
of
is clear.
March 2018, which was 2 years after this whole issue had started.
You also stated that you made some out-of-pocket expenses.
Yes, I did.
Did you get approval for these expenses from the defendant?
I made those expenses in the course of carrying out my official duty. The defendant gave me duties, assigned me work to do without paying me float to do them. And because I was responsible enough to carry out my duties, of course I carried out my duties. I was expected to work even when I wasn't paid float or salaries, and I did my work. So I'm not sure I understand what your question is exactly, please.
Did you get approval for those out-of-pocket expenses? Yes or no?
I did not need to get approval. I was sent on assignment and I took out my assignments.
Court places, you don't need to get approval.
No, I did not need to.
As a court
If it was an indictment on the defendant that they sent me on assignment without giving me the necessary tools and funding for it, and still held me accountable for those periods.
My lord, sir, I need to be protected. See, I just have few direct answer questions.
You don't need any protection.
Maybe
She said
need to be told.
made out of pocket expenses in the course of carrying out her duties as assigned to him. That she did not apply for any out of pocket expenses because, I mean,
very rarely, man.
She should just answer and we move on.
Unfortunately, Mala, it doesn't work that way. You can ask direct questions. You don't expect direct answers coming from somebody that is feeling victimized.
Well, I don't know about that one. So that's what we're here to talk about. Yes.
Okay. You also claimed.
Counsel.
Hello, sir. As a couple, I would have concluded this process if the witness had been so cooperative. But she seeks to give further explanations to every answer. So you claim, Madam Ifioma?
Yes, please.
That a particular male traumatized you. There is a male that traumatized you. Male required resignation.
Yes, yes, I did.
That you were traumatized by a particular
Yes,
man.
yes, yes.
You said so.
You tendered the resignation letter on 15th of June,
Yes,
2016.
yes, I did.
That news came out in the same June. Is that correct?
That
The news of your resignation came out in June too, in the month of June. Is that correct?
yes, it was.
You did not mention the date and the name of your co-workers that told you or gave you this fact in your statement before the court, yes or no? You didn't mention their name, you didn't mention the date. Am I correct?
No, I didn't. No, I didn't mention their names, and I didn't um state the date. Yes, that's
Thank you
right.
very much. And you will agree with me that your resignation mail was not sent to one person. Is that correct? That mail wherein you resigned was not sent to one person.
I believe it was sent to the person that sent it to me, and to be
The
honest,
mail that you sent for your resignation, that's what I'm referring to.
A letter of resignation.
Yes, was not sent to one person.
I would need to confirm. It was sent to the relevant parties. I would need to.
Document will speak for itself.
Will have shown that
The
document.
document will speak for itself.
Accomplices.
I don't know why council is
No.
hammering on that. The document will just speak for itself.
As accomplices.
The person that are copied in the mails
People that
will be
copied
reflected on the document.
Sent her letter of resignation. You're saying it was sent to more than one
As
person.
accomplices, and you should answer.
I mean, did you send it to more than one person? Your letter of resignation?
I
It's
would
saying
need to
you sent-
I would need to
Okay.
confirm. I probably sent it to the HR, and I don't want to say anything without confirming. I would just have a look at that mail and then get back to the court. I have my system here. I'm just going to have a look.
She said she probably sent it to one or more persons, but she
As
cannot say
accomplices,
for
it is clear.
until she.
It is clear, my lord.
Yes.
The documents are before the court. Just wanted to confirm if you didn't. As accomplices.
Okay, since you have the documents, can you please confirm for the court who was copied in the email?
It's your document, it's your mail.
Well, I've actually answered. The document speaks for itself. Now the witness is also acting like she's the lawyer, telling the document will speak for itself. The document speaks for itself.
My lord, it is not as my learned friend paints the situation before the court. And it's not a joking matter. She made heavy allegation on the issue of being traumatized about the mail. And the question,
Yes,
did you send it
I
to one
was
person?
traumatized.
Did you send it to one person?
Well, I have not started appraising the facts, so I have to put down what you ask and what she replies.
As a couple,
I'm just trying to go back to that email. Okay, just bear with me while I pull that up.
So,
actually, before you do that, it should be by leave of court. Francis.
Oh, sorry, my
Ask
lord.
for leave of court to
Sorry, my
refresh
lord.
your memory.
Sorry,
Yes.
my lord. I'm really sorry.
As a
Please.
couple.
Thank you, my lord.
Apologies, my lord.
no, well, okay.
Meanwhile, can we go on?
Okay.
Yes,
Madam
please.
Chairman,
Yes.
let's proceed, please.
Yes, please. I can hear you, but I don't care.
Can I have you here?
Yes, please.
How come you became traumatized by the news of your own resignation?
Okay, so if you read the statement well enough, you would see that I wrote that I was traumatized by the events, the fact that the company had gone ahead to announce to the company, to the workers, that I had resigned when I was not even aware that an email was sent to me advising to resign, and when I had not resigned. That was what the trauma was about, and not my email. I couldn't have been traumatized by an email that I wrote.
Well, I think we've recorded this before. She said that even before she resigned, there was communication to other staff that she had already resigned when she had not. Yes.
You agree with me that you signed another contract of employment with the defendant dated 25th of April 2016. Is that true?
Another contract of employment? I don't believe so.
We front-loaded it with all our team of defense.
Sorry?
So that is dated when? The contract letter?
We front-loaded the document, the new contract of employment.
What date was on the letter?
25th, my lord, of April 2016.
Okay. And what is the answer?
I don't believe so. I don't recall. I only signed one contract, and that was when I began my. I'm not aware. I can't recall any such. And in any case, I wouldn't be signing a contract whilst still working. It wasn't. I'm not clear about that.
You resigned as what, the defendant? What position did you resign as?
Business manager.
And your contract of employment, that's provisional letter of employment, read area manager. Am I correct?
Yes. Sorry, can I ask a question, please?
You can ask me a question. Answer my question, please.
I have answered you, and then I asked if I could.
And that provisional letter read what? She
Read
resigned as
area manager.
Area sales manager, which was stated in my statement of oath that at some point my
just hold on.
Okay.
Yes, go ahead.
She resigned as business manager.
It's on record.
Yes, it's on record. I stated that in my oath. Yes.
Hold on. I could have, she's here in person. I could have shown her a copy of the letter of employment. I wouldn't know how I could do that.
You can bring it.
As a copy.
I did mention in my statement of oath that my original title was area sales manager, and at some point it was changed to business manager.
Okay. So my lord, she signed another contract of employment.
Okay.
On 25th of April, 2016. That's the document. Our signature.
Did you say 25th of April, 2016?
Yes, confirm your signature, please.
25th of April, 2016. I was on maternity leave on the 25th of April, 2016. So I'm not sure. In fact, I was in the hospital
Is that your
Where?
signature on that document?
I'm sorry, I'm just referring to the date. You said 25th of April 2016. I was in the hospital due to deliver my baby on the 25th of April 2016.
January.
Okay, sorry. I'm so sorry. I'm so sorry, my lord. I'm so sorry. It's 20th of January. Please confirm your signature on that document.
Can you see this document? Francis, can you see this document?
No, I'm not seeing it on that. Maybe there's another camera.
Okay, this one.
The signature.
Your signature.
Let's see. Yes. Yes.
That's your
Yes.
signature.
Yes.
Hello, we seek to tender the contract of employment dated 20th of January 2016. It is there. We attach it to our statement. It is pleaded.
No, this is the first time I'm seeing this document or hearing about it.
Where's my defense? First page.
Apologize, ma'am.
No. You take your time and sort it out. How many more? Go.
Let me choose this document.
I have the document.
And even if it's not pleaded, it's relevant. With our signature, shall recognize it.
No.
Well, it wasn't pleaded, and this document is in shreds. I can't confirm that that document is a document that I recognize. So. Trial.
No?
It was not pleaded.
It was not. It was not. No.
So did you plead this document?
No.
Did you plead it?
It was never.
My lord, sir, I understand by elementary principle of law that it is not only by pleadings that document can be admitted before the court. Please let me address the court. You did address the court. I did not interject.
No, but this is just coming from nowhere. Not giving me time to even have
was it pleaded?
No.
My lord.
Was it pleaded?
No, it was not.
My lord, it was pleaded.
It was not.
Because it was front loaded.
It was not.
Okay, not
and this
pleaded.
is the first time they are seeing it, my lord. The court can confirm by record that it was front loaded, and it is indeed relevant to the fact in issue before the court.
Okay, in that case,
has attested to the fact that that is her signature on the document. She has confirmed.
No. Please, I haven't confirmed anything.
Madam,
please,
hold on.
I have not confirmed anything. You just bring in a document before me. It was never mentioned before now.
You have educated this witness. You will have told her how proceedings of court is done.
Now, counsel. Now they are saying that this document is relevant to the proof of their own case, side of the case, and to that effect, it is relevant to their case, and it's admissible for whatever it is worth. So, in line with the practice of the court is going to admit it, and in your final written address, You can attack it if you like. This is listed.
It's not.
Okay.
Show my documents to go through.
Also, since this is your document and maybe that you have you need it to prove a point, maybe you keep it in when your case
As
is
a point of reply or on point of law, not all documents. God, my Lord, I tendered this document during cross-examination. It is a previous duty of the defendant. My Lord, whether it is pleaded or it is front-loaded, the major thing, my Lord, whether it is relevant to the fact in issue. My Lord, the defendant that confirmed before this court that she signed this document.
No, I'm sorry, I haven't confirmed that, please. Because I need to see this document to be sure that I've signed it. I'm sorry. I'm sorry. Please. My lord. My lord, we thought.
Look at it again.
My Lord, and there are facts in our pleadings pointing to the relevant document.
Are you looking? Okay. Is it showing? Okay. Did you sign that?
I want to show witness the signature portion. It will be shown.
I need to see the document and know what it is. I need to see the document and know what it is.
She's
my Lord, I
shown
the
the first
by the counsel on the other side. How could you be alleging fraud? What do you mean by it is fraud? You were not there when this are relating.
We have 3 other matters to try.
You were not there, so you cannot give evidence.
Based on the rule says all documents must be listed and concluded. Not just concluded.
My Lord, there's an exception to document tendered under cross-examination. It's an exception to the rules of pleading document.
All the documents tendered must be pleaded. The rules of this condition.
Please let me be sure about this.
Lord, the rules of court is not superior to the Evidence Act. I'm so sorry, my Lord.
Yes. This document is titled Employment Contract, dated the 20th day of January 2016, between Tayonex Nigeria Limited and Ifoma Ezekaka. Now, at the end of it, the document is signed. So he asked you, he asked you before, do you remember having signed another contract apart from the one you called, what did you call the other one?
Provisional offer.
Employment. Apart from that, did you sign any other contracts?
My lord, I may have, but I can't be too sure because I don't recall. That's what I'm trying to say. And right now, I feel like I'm being ambushed.
I recorded that saying you probably did, but you are not too sure. That's what I heard. Now, because you said I probably did, he is now showing you a document to try and let you find remember whether you signed any such document as this. That is employment contract between you and the defendant.
I may have. I may have.
Witness, can you go through it? You have to go through it properly. That is what the court is telling you.
Yes, because I need
to the document. Did you? My lord, I apologize.
You cannot go through these documents now.
My lord,
because it has 3 minutes.
My lord, at this point, these are the only challenges we'll be having in virtual hearing. But I know it's not difficult, my lord. We'll take it close to the witness to affirm whether she's seen that document before. She haven't seen the signature portion.
No. Okay. Look at this.
We can see from the screen, my lord.
Okay.
Please.
I gave her the first page is employment contracts. Can you remember? The point is, she said she probably signed this, but she cannot remember. So does that mean that she didn't or that she did? So that's the point. If she did sign it, then it can go in through her. It can go on through her. Are you with us?
Yes, I am with you, my lord. What I can say at this point is, like I did mention in my statement of oath, at some point, the designation was changed, okay? And I may have signed the document, but what I'm going to just say now, oath, is I would need to confirm the content of that document to be sure that it was a document I signed.
Okay. In that case, we take a date.
Hello?
In that case, we take a date. Maybe you can send this and send the soft copy to her.
My lord, sir.
Yes.
Very grateful, my report, sir.
Yeah.
With a disposition of Supreme Court as at 2020 on document not pleaded. My lord, Honorable Justice Okoro, JSC, my lord, stated in the case of Sunny against Kogi State House of Assembly, 2020, all Federation Weekly Law Report, my lord, at 1030, pages 227. My lord, this is the position of the court, sir. It is an integral part of the law of evidence that documentary evidence need not be specifically pleaded in order to be admissible in evidence, so long as facts and not the evidence by which such document is covered are expressly pleaded. My lord, this document is in its original form. It's not vitiated by any position of law. My lord, and there are facts, and the claimant in her examination has agreed that she was formerly area manager and later she was business manager, and that someone gave birth to being a business manager, and that was caused the new employment in January. And this document was also front-loaded. This document was served on the Claimant Council on 25th of October 2022. And
it was served on the Claimant's Council.
And it is the first part of the record of this court, my lord. My lord, it is relevant to all the facts in issue. She has been led to
Claimant Council. I never knew this was served on you then.
How do you mean?
No, it wasn't served.
I thought the position was that it was not pleaded, it was not front-loaded.
Yes, my lord.
So you've never seen it, and
You've
she's
never
just
seen
saying
it.
No.
We've never seen it. There's never been any mention.
My lord, particularly, I have asked, my lord, just to finish, my lord, I have asked for the umpteenth time that what paragraphs of the statement was there such pleadings that were accommodated.
Counsel, please note, I'm not disagreeing with what you have just said. Yes, but you know we are conducting this trial.
Yes.
And the judgment is for A as much as it is for B. Now, whether this is relevant or whether this is going to play a vital part in the judgment in this case, the court doesn't know because I'm gathering evidence. Now, I don't think it's not fair to show somebody and say, did you sign this? Okay, and you put it through her. She said she needs to look at what she's, I'm asking her whether she signed. I think she has the right to go through it. If she signed it, then it can go through her. Why and why not?
As a
but if she didn't sign it, then we record her saying that she didn't sign it.
As a
Then as you argue, adjourn your issues, then the court will know what to do.
I agree with my lord. Totally, my lord. And I'm learning from the bench.
So, what you're saying involves the point at which it may be admitted or not. I'm not disagreeing with anything. I'm just saying let her know what we want her to identify as what she signed. Because she said probably, and that she would like to see it. And you're out of time. So that's why I said let's just take a short adjournment. We will do justice to it. Please.
One last thing before we go on adjournment. This court can take judicial notice of the record before it, whether the document was front-loaded or not.
Of course.
What we serve on them is a counterpart of what is in the court file. We are not trying to smoke any document in, my lord.
The court knows that. I appreciate that. I know that. So, counsel, I think you have to help us now. You scan it and send her the soft copy.
We'll do the needful, my lord.
Then by the
We'll conduct research on the court's file.
Because I guess she's sworn on the Holy Bible. So I don't think she will mislead the court because that's another offense altogether. So when are we coming back?
Hello, will be guided by the court's diary.
Only early.
Yeah.
Oh,
yeah.
But we have about 2 or 3 cases yet to be heard. And time is really gone. Today is 16. When? 14th of May 17. Short. You have to remove the election, you remove the Easter break, it becomes short. When? 17th and what? Of what? May, my lord. No. Yes.
I'm returning the document to him.
Yes.
May 17th.
Is a convenient date.
That's my
lord. So how do you stand on that 17th of May? Yes, is that all right? How about you? So this matter is now adjourned to the 17th day of May 2023 for continuation of the.
Thank you.
We are sending back questions. But the council is supposed to have that in his find out that documents and thank you. Okay. Now, witness, where is it? Okay. Hello?
Yes, my lord.
Francis. Okay, all
Yes,
right.
my lord.
I don't know if you've heard about if you've heard the adjourned date.
Yes, my lord.
The matter has been adjourned, and on that date, it would be very good if you are present, so that we conclude your evidence on that date.
Yes.
That's
Yes, my lord. I'll
17th
be
of May.
present by
Yes,
God's grace.
please.
Yes, my lord.
Yes. All right. Thank you.
Thank you, my lord.
Eh?